So I'm here to talk about non-compete agreements. So I'm sure some of you know, some of you may not know, Massachusetts passed a Non-Competition Agreement Act, which impacts what non-compete agreements can look like in Massachusetts. And there's been some significant restrictions, and it impacts employers in significant ways because of if you don't meet the requirements, the non-competes aren't going to be enforceable. And in some instances, particularly without cause termination, it's not going to be enforceable. But let me go through it in more detail. So first of all, the Act covers non-compete agreements that are entered into after October 1. 2018. So if you have existing agreements that were entered into prior to that, those are all still valid. If they don't meet the requirements of the statute, it doesn't matter, they're still enforceable. But it's everything that were entered into on or after October 1 that has to comply with the statute to be enforceable. So what is a non-compete under the Act? A non-compete under the Act is an agreement that provides that an employee will not engage in certain specified activities that are competitive with the employer after the employment relationship has ended. Interestingly, the definition of employee under the Act includes an independent contractor. And as some of you know, I'm sure, it's hard to be an independent contractor in Massachusetts. There's another statute. You have to meet 3 requirements in order to be one. But if you do, and you have an agreement with an employer or a business, and there's a non-compete in it, it also has to comply in order to be enforceable against you, or if you are the employer who has hired or retained that independent contractor to be enforced against the independent contractor. So I'm going to start first with what it doesn't include, because there's a large subset of what a non-compete is not considered under the Act. It does not include agreements not to solicit or hire employees. It does not include agreements to not solicit or transact business from customers, clients, or vendors. And it does not include agreements that are outside of an employment relationship. It also does not include agreements made in connection with the sale of a business, where you're selling substantially all the assets or ownership interests. However, in order to meet that classification, the party that is restricted has to be a significant owner of the business, and receive significant consideration or benefit from the sale. And you'll note that a significant owner or member of a partner in the business entity, a business entity can be a person, a group of persons, an LLC, a corporation. So it does not have to be a formal business. If you're running a business as a sole proprietor and you sell it, you can be subject to a non-compete. And again, it does not have to meet this statute. It does not include confidentiality agreements. It does not include invention assignments agreements. And it does not include non-compete agreements that are made in connection with the separation of an employee. So normally you have an agreement with an employee at the beginning of the employment, you have them sign a non-compete, a confidentiality, which contains confidentiality, non-solicit, all of that. The non-compete provision can be enforceable if it meets the Act. If you don't have one of those and you terminate an employee and say, I'll pay you X in order to non-compete, and if you won't compete and sign it, at that point in time, you can do that and you don't have to comply with the Act. Obviously, that's a more difficult situation because the employee is not bound at the time you terminate. There's some nuances which I'm going to go through that can maybe help you position into that so that you can get that non-compete, particularly when an employee is terminated without cause, and we'll talk about that in a minute. But essentially, if you enter into a non-compete at the end of your employment, that will be enforceable. The one caveat is you have to give the employee the right to rescind the agreement within 7 business days. In addition, the other thing is, I know some of you have seen provisions where you have the employee agree not to reapply under certain circumstances when people are terminated. That also is not within the Act, and those are enforceable. Let's talk about how you make a non-compete enforceable. So the minimum requirements for enforceability are you need a signed written agreement, you need to provide the agreement before the offer, or 10 days, business days before the employee commences employment. And the reason for that is to give the employee time to consider it, essentially is why they've set that up that way. If you enter into an employment agreement which contains a non-compete after the employee starts at the company, you have to give the employee 10 business days notice with regard to the agreement. And then you also have to provide fair and reasonable consideration. And that fair and reasonable consideration has to be more than just continued employment. That would not be sufficient. You would have to give them a bonus or some other consideration in order for them to sign. And this is after they've already been employed. The non-compete agreement cannot be broader than necessary. So again, it's the same 3 factors that you look at, we looked at before to determine the enforceability of a non-compete, which is it can cover, it's there to protect trade secrets, it's there to protect confidential information, and it's there to protect goodwill. So you want to have it crafted such that from the agreement you can certainly substantiate that it's reasonable in terms in order to protect those 3 things. It doesn't go beyond that. You're not trying to limit an employee beyond protecting those legitimate categories. The agreement cannot exceed 12 months. That's very new. Typically, many companies had employment agreements with non-competes that went for 2 years, 18 months. Well, now you're limited to 12 months. It has to be limited in a geographic scope. That geographic scope has to be a reasonable geographic scope. Generally, if it's an area in which the employee worked, was materially present, provided services within the 2 years prior to termination, that would be presumed to be reasonable. So again, that's factually, you got to look at that to determine whether you need to limit the scope, the geographic scope, within the agreement when you're drafting it in order to make sure it's enforceable. Going back to the 12-month restricted period, that period can be extended in certain circumstances. Basically, if the employee breaches his fiduciary duty or physically or electronically takes company property, you can then extend that agreement. So what I'm seeing now in agreements is there are clauses that expressly set that out, that if you breach your fiduciary duty or you take company property, then the non-compete will automatically expand to 24 months. But you can't exceed that. Next is it needs to reasonably prescribe the activities. And what we mean by that is, what was the employee doing? If you're in sales, then we're going to limit you with regard to sales. We're not going to prevent you from competing in some other area of a competitive business. So again, you've got to look at the facts. What's this employee doing? Be a little bit more specific within the agreement to specify this is what we're restricting you from doing versus just a broad, you can't compete for the company. So if I was in sales and now I'm going to be in research and development, the employee would have, I think, an argument there that the non-compete, if it covered that, would not be enforceable with him participating in the research development and not in sales. All of the non-competes have to be supported by consideration. The statute provides that if you have a garden leave clause, that's sufficient consideration. And then it has this nice broad term, or other mutually agreed consideration. Nobody knows what that is yet. There's no case law on this. So you'll see in agreements now, people are, and I'll give you some examples, are playing with this to try to meet this requirement and not have to be stuck with the garden leave clause. Well, what's a garden leave clause? A garden leave clause is basically the 2 bullets below. 50% highest salary within 2 years, that's what you have to pay the employee in order to meet the garden leave clause requirement. So it's half a year's salary. And you pay it pro rata over the period of the restriction, which would be the 12 months. And it has to be treated as if it's wages. In other words, you pay it along with wage payments. You do it with payroll. You treat it as if it's a wage payment. The employer cannot unilaterally discontinue payments of this garden leave clause unless the employee breaches the agreement. So you're bound in to pay 6 months over 6 months salary over 12 months. And you can't unilaterally terminate those payments unless the employee breaches his fiduciary duty or breaches this garden leave clause. I had mentioned that 24-month extension. If you can do that 24-month extension as a result of the breach of fiduciary duty or as a result of the taking property, you do not have to pay during the extension period. In what circumstances are the agreements not enforceable? One is they're not enforceable against a non-exempt employee. So that means any employee who is eligible for overtime, no enforceable non-compete against that employee. They're not enforceable against undergraduate or graduate students in internships or short-term employment. They're not enforceable against employees that are terminated without cause or laid off. So you can have an agreement signed with the employee, exempt employee, and then you decide it's not working out, I terminate them. There's no employment, no non-compete as to that employee. Again, we're going to talk about ways to maybe get around that to the extent there's a concern there. But that's a big, big loophole. That's a big change before what we used to have under the old law. And you can't enforce it against somebody who's age 18 or younger. Interestingly, even if you have a non-enforceable non-compete, it does not void your non-solicits or your of employees or of your customers. And there are circumstances where you could go into court to seek enforcement of a non-compete, even if it was non-enforceable. That's still allowed. I think those circumstances would be pretty limited and hard to meet, but that is a possibility. And you can't avoid the statute and avoid these restrictions by putting in a choice of law. And let's say, we're going to apply North Carolina law, particularly as to an employee who was a Massachusetts resident on termination and was Massachusetts resident 30 days prior to termination. So you can put a choice of law in there, but it may not work. And certainly, even with a choice of law, courts may not enforce them, depending. If you've got an employee who's really not working in Massachusetts, all the work they're doing is down in Texas, you may run into issues there just with the court. But under this statute, it expressly provides that if the person is a Mass resident at the time of termination and had been a Mass resident 30 days prior to that termination, if you have a choice of law of another state, it's not going to be enforceable. This statute is going to be enforceable. So, caution. The agreement needs to be carefully drafted to comply. So, I know we're up here, we always give you advice, but this is one area you really should at least talk to an attorney, even if you get an agreement set up, a form agreement, so it meets the requirements going forward. There are other statutorily required conditions that I haven't mentioned. I'm not going to bore you with the legalese. There are things about you have to have a right to put in there a right to consult with an attorney, issues with regard to consideration and whatnot. But again, that's why I really think you should go to an attorney to at least get a form so you can use it going forward. So what have I seen companies doing now as a result of this statute? There are people that in the agreements are now putting a lot of detail about what the consideration consists of, and that's to meet that other mutually considered consideration clause. They're putting in statements to the effect that it's employment, because I'm hiring you. These are ones when you're hiring an employee at the time. I'm giving you access to key relationships. I'm giving you the ability to participate in our benefit plans and programs. And it's not just, and I'm giving you, $30 or $100 or whatever. So they're really trying to emphasize all the things we're giving you as part of it as an employee to say that's the consideration for this. Will that be enforceable? Remains to be seen. And we'll see what a judge will do with that. What I also see is that people are structuring agreements so that there's an execution of a non-compete upon termination. Now, you can't put in the agreement, when I hire you, you're going to execute a non-compete when I terminate. I don't think you can because you're agreeing ahead of time. The agreement has to be in connection with the termination. So what I've seen is people will say, I'll pay you a severance on the condition that you do three things. You return property, you sign a release, and you execute a non-compete. That I think would work because they haven't agreed yet, and at the end of the day, when I'm terminating you, I'm saying, I'll give you X if you give me Y. So that's another way people have done it. Another way people are attacking it is the definition of cause in your agreements. This is usually a tug and pull between employer and employee. Employees want very restricted cause, very limited, very small, short. I committed a crime. Employers want it broader, and now what employers are doing more are putting in a clause to the effect of if you fail to perform or your performance is not adequately satisfactory to the company. That's a pretty broad loophole. That's effectively, you're not making the grade, you're gone. And then the reason to do that is to say, I can point to the agreement and say it's cause. Now again, could a court twist with that? They can, but at least if you define cause to include just a termination when somebody's not working out, you at least have that argument. Therefore, if it's not without cause, it's enforceable. I'm seeing people put in provisions that provide that, well actually this is a thought I had. I haven't seen this one yet, but this is a thought I have, is that you have a good reason clause. If people are familiar with that, good reason clause, the employee can terminate if you reduce their salary or if you reduce their authority and responsibilities. So what an employer, I think, could do that could work is you could reduce, even if there's a good reason clause, you reduce the salary or you reduce the person's authority, then the employee raises their hand and says good reason and terminates. They terminate. It's a voluntary termination by the employee. It's not a termination without cause, in which case the argument would be that the non-compete is enforceable because the employer didn't terminate without cause. Again, I'm not sure that would be enforceable. I'm sure there would be some arguments to say you're effectively compelling the employee to terminate, but that's a possibility to use if somebody wants to be on the cutting edge. I'd be happy to draft it for you. The other is you tie the severance to, obviously, the non-compete. So we'll pay you a severance, but only if you sign a non-compete. Most employees are going to be sitting there weighing the benefits of signing a new non-compete, a termination, or taking the severance, or saying, no, I'm going to go work for the company. Obviously, if you terminate somebody and they aren't in a position where they're taking a job, they may be more apt to say, fine, I'll take the severance. It gives me time to, I'm not going to compete. I got to go find a job anyway. I'll take it, and that would give you that protection. And then the last, I think I mentioned it earlier, is people are putting in provisions that expressly provide for that 24 months kick-up if you take property, which helps you enforce people not taking your property when they leave, documents and whatnot.